recording. Okay.
Okay.
Cool. Recording. So let me just introduce the webinar topic and series, just to mark it for the beginning of our recording. So guys, this is October webinar. This is Mike Chait talking about employment basics for your small business. Shout out to the Vashon Chamber and Vashon Be Prepared, sort of sponsoring and really supporting this webinar series, just to kind of help the local economy, local Vashon businesses kind of be supported and everything as we come back from COVID. So yeah, without further ado, I'm going to mute myself, and then Mike, if you want to take it away.
Sure, and nice to meet you all. I'm Mike Chait from Montgomery, Starp, and Chait. We do all types of law, but generally we represent businesses and like to provide advice and counsel and litigation for folks. So without further ado, I'm going to kind of jump right in. What we're going to talk today is about a number of issues facing you as a small business owner. So there are a lot of these memes going around for small business owners, but the commonality in all of them is a whole bunch of underlying issues that the guy is exempt if they have a lot of discretion in what they do. But if you have someone who's, an office manager and they're really just doing clerical work, they will not fit under this description. And then lastly, you have the professional job functions. And that covers jobs that require a high degree of specific schooling or accreditation, like doctors, scientists, lawyers, accountants. It can include broader things, but one of the big things for that test is the amount of schooling that's required. So, even people like chefs can fall under this if they're executive chefs and had to go to a certain amount of culinary school to achieve that. They can fall under the professional function. It also covers creative professionals, and this is about as clear as mud. That's folks whose jobs require endeavor. So they has the right to control or direct the result of the work, not what will be done and how it will be done. And that's kind of really the biggest piece of this determination on another. Obviously, a contract and a title are not binding on you, but they are useful and they are some evidence of the type of relationship. Benefits, another important part of the relationship. If you're providing benefits, you're almost certainly an employer. Permanency of the relationship, an expectation that the relationship will continue indefinitely rather than for a particular job. Again, generally evidence that there was intent to create an employee-employer relationship. And the extent of which services performed by the worker are seen as a key aspect of the regular business of the company. So that's in general the federal test. Like I said, that's the IRS test. I want to just go over the Washington Labor and Industries test, and I'll just kind of make this brief. The big difference here is that under the state test, you have to pass one of these three options as one of the other things, in addition to kind of the control stuff we talked about with the federal test. The service that the contractor is providing is outside the usual course of your business. So are they doing something for you that you're not doing for yourself internally? So that's one way you can pass it. The service being performed outside all of the places of business. Are they doing this from their home? Are they doing this from their office, as opposed to, just coming in like all the rest of your employees? And lastly, the other way to get around is that the individual is responsible for the costs of their principal place of business where they're doing this work. So again, if they're doing it at your location, they're probably an employee and can't pass that. Similarly, they need to, or in addition to that, they need to pass one of the following options. They need to be customarily engaged in an independent, established trade, occupation, profession, or business of the same nature as that involved of the contractor service they're doing for you. So, think about a normal contractor we might hire I have an electrician at my house today. They are just doing work on my house for a single time. They're customarily engaged in doing electrical work and are doing it for lots of other people. And then the other way to meet that test is to have a principal place of business eligible for business deduction for IRS purposes. So that involves, how are they doing their taxes? Are they claiming, to have a work site that they're using for their IRS purposes? We can kind of just skip this because this is similar, as I said, to the IRS test. So why is this important? One word: money. It's undoubtedly cheaper for an employee or an employer to have a contractor doing the work rather than an employee. The company is not paying payroll taxes, not paying L&I, not paying unemployment, and isn't subject to things like overtime. Now, that could change. Like I said, you've probably seen that there have been a lot of laws that have been passing in other states, California most notably, to address abuses of the gig economy. But the other side of the coin is that it's important financially for all of these government agencies too. They want and need you to pay for the employment protections like workers' comp, like unemployment. So they're enforcing these laws and they're going after folks who misclassify. So the consequences of misclassification are substantial. Classifying an employee as an independent contractor with no reasonable basis to do so can make you liable for those unpaid employment taxes, potential back pay that can include overtime pay, civil penalties and interest for failing to pay workers' comp, and failing to file accurate unemployment tax reports. Now, obviously, as a small business, you're a small fish in a big pond, but it is still a real risk for you and worth your time and focus in figuring out whether people are appropriately classified and paying them as such. So next, I want to jump into a couple of new things that have been happening that you as an employer need to know about. These are new laws that have gone into effect that directly impact you. We're going to cover Washington's new sick leave law, Washington's new parental leave program called the Paid Family and Medical Leave Program, the new long-term care law, which goes into effect January 1st, Washington's changes to non-competition agreement law, and last and least, COVID and what we need to be doing about that. So Washington's new sick leave law. So this was passed by voters in 2016 as part of Initiative 1433. So as an employer, you must offer sick leave for your employees. That's a big change. A lot of businesses did that. It is now a requirement of the law. So at a minimum, you must provide 1 hour of paid sick leave for every 40 hours worked by an employee, regardless of full-time, part-time, temporary, or seasonal status. You also have some choices about what your policy will include. But again, I'm going to give you kind of the bare minimum that you have to do. So this hour of paid sick leave for every 40 hours worked by an employee can be used for the employee. It can be used for a family member, for illness or injury, physical or mental health conditions, doctor or dentist visits, preventative care, children's work or school closures for health reasons. And this applies not only to the employee, but also to a child, a parent-in-law, a spouse, a grandparent, a grandchild, or a sibling. You have to pay your employees normal hourly rates for paid sick leave hours that they use. You have to allow your employees to use those to care for themselves, again, or their family members no more than 90 days after they start working for you. And once the employee becomes eligible to use accrued paid sick leave, you must make paid sick leave accrual available to employees for use in a manner consistent with your established payment interval. So you have to give them that with their next paycheck if they take a sick day under this rule. Now there's a bunch of other details about this. Let's see, did I put that note? You have to notify your employees of their paid sick leave rights by their first day of employment. So again, kind of with your onboarding papers, you should include a specific notice about this law, explaining what it is and what your policies are. So like I said, there's a bunch of details about what you can and can't do. There is value to you as an employer in creating a written policy about this. And again, that can go into the notice. But if you have a written policy, there are certain things you can do that you can't otherwise do. You can't require employees to cover their shift before they take sick leave. If they take leave and they don't cover their shift, it's going to be on you as their employer to find someone else to cover or cover it yourself. One of the things that you can do kind of to protect yourself, again, only if you have a written policy, is to put in there a notice requirement. So for things that are not emergencies, for not acute, but like say a dentist appointment, a doctor's appointment, you can say you need to give us at least 10 days notice of that so that we have an opportunity to find someone else to cover your shift. Then you're not in a jam covering their shift yourself. You can also, if you in a written policy, have a verification requirement. So if they miss more than 3 days work, you can say you need to get a doctor's note. Now there are other nuances to that if you want to do that, but that is something, again, only available to you if you do a written policy on it. One thing as a practical matter too is that you have to carry over up to 30 days. Sorry. You have to carry over into your next year sick leave balances of 40 hours or less. Again, this is a good place to put in your written policy. You can do more, but so if someone works for you and they accrue enough time that they have 40 hours of accrued time at the end of your fiscal year or the calendar year, depending on what you're using, you have to carry that over so that they will start accumulating with their next 40 hours so they'll have 41 hours. But you don't have to pass that along any further, and you don't have to pay that out if they leave you. You may have to come back. If they come back within a year, you may have to reinstate that, but you don't have to make a payout. Again, if you have a written policy, that's a great thing to include in there, just so that there's no confusion about what will and won't be paid. So as you guys know, vacation time, you do have to pay out when you fire someone or when they leave.
Quick question, Mike.
Yeah.
I just want to make sure I heard you correctly. So sick pay does need to carry over based on whether they've accrued up to 40 hours, or was there a specific amount of hours of accrued sick leave that dictates whether it gets carried over, or is it no matter what?
Yeah, so no, the sick leave does carry over. You can cap the amount of sick leave that carries over at 40 hours. So if someone, has 80 hours of accrued sick leave at the end of the year, you can say, okay, so tomorrow you go back down to 40 hours, and then they'll start accruing an hour at a time with each 40 hours work after that.
Okay, so it's it's a minimum of 40 hours that has to be carried over.
That's correct. Because what they don't want to have is a situation where, you know, someone has 2 weeks of accrued time, calendar year goes over, January 1st, they get sick and their balance is at 0, and all of a sudden they can't take sick leave. So this is to give them a minimum amount of sick leave each year.
Okay. And then I may be jumping the gun here, but as far as what qualifies for how they can use that sick leave, is there technically a legal definition of what that can be used for, or is it kind of broad and dependent a bit on the employer's okay?
No. That's a great question, and there is a definition. And this may be shortening a little bit. You can look at the regulation itself, but in general, it's illness or injury, physical or mental health conditions, doctor or dentist visits, preventative care, and children's work or school closures for a health reason. And again, this applies to child, parent, parent-in-law, spouse, grandparent, grandchild, or sibling. So, you know, you see this coming up a lot with the school closures for COVID. That probably would be an event that if they were your children or grandchildren, or frankly, even a sibling, that would be a covered event that would fall under what they can take sick leave for.
So, so we had an experience last year where one of our employees had 2 different times throughout the year had an exposure situation and needed to quarantine for both of those times for, you know, approximately 10 days each time. We used the sick leave towards that, but I was a little unclear as to whether that is applicable, or if it's legally required by the employer to also cover for that quarantine period. Maybe you're going to cover that as we come into the topic of COVID, but
yeah, that's an excellent question, and it's different this year than it would have been last year. I don't know that if there is guidance on that in Washington State under this specific law. Last year, there was a federal law that covered that. That federal law expired as part of the stimulus package. So there were specific rules about quarantine and what you had to allow for quarantine and what percentage you had to pay under the federal stimulus package. Those have since expired, and so there's no new federal regulation. You know, as a practical matter, I think what you did was probably a smart thing to do legally. And I think last year you probably had to do that. I think it's a closer issue this year, and I suspect there will be more guidance on that pretty soon, because, you know, it's going to happen, and it's going to happen a lot. My guess is that they would allow that to qualify as sick leave under Washington law.
Great. Thanks for answering those questions.
Okay. So let's jump ahead, unless anyone else has any questions on the sick leave. But let's jump ahead to the paid family and medical leave program. So this is actually a really great program for employees and employers alike, especially small business employers who otherwise wouldn't be able to afford offering paid parental leave. There are lots of laws protecting a pregnant person's job, although a lot of those don't actually apply to small businesses. We're not going to go over those today, but what I do want to go over is Washington's paid family and medical leave program. This was one of the first paid parental leave programs in the country and went into effect in 2018, but the payouts under the program only started last year. So we're just seeing this really come into play. In general, this benefit is paid by the state and allows employees to take up to 12 weeks as needed if they experience a serious illness or injury, need to care for a seriously ill or injured relative, need time to prepare for a family member's pre and post deployment activities, as well as time for childcare issues related to a family member's military deployment. And this is paid at a rate of 90% of a weekly wage up to $1,206 per week. So if an employee is making anywhere below about $70,000, they'll be getting 90% of their wages. If they make above that, they'll be getting this $1,206 per week, which is about $5,800 per month. There are procedures available too, if you as an employer want to offer a supplemental benefit to make up the difference between the state benefit and the employee's actual normal wages. That's entirely voluntary though. This is paid for by a 0.4% tax on gross rate wages, with the calculation of gross wages, including most things other than tips and payments into retirement or disability plans. And typically this split is 63% employee and 37% employer. However, for small businesses, those with under 50 employees, you're exempt from paying the employer share. So really, this is a great benefit for small businesses to help their employees in these situations without real cost to you as the employer. Okay. Next is the new long-term care law. So employers with Washington employees are needed to prepare for this. This is going into effect January 1st, 2022. Again, this is not really something that you need to look into in terms of paying for, because this is an employee-funded program. But it is something that you'll need to do just in terms of your payroll. You are going to be responsible for collecting and paying the employee portion of this. What the program is, it's actually, again, first in the country, state-run long-term care insurance, and it provides a benefit of about $36,500 to eligible residents who need assistance with activities of daily living. So like the parental leave law, the benefits of this won't actually be available for several more years while the fund is built up, even though they're going to start collecting the money for it starting in January. So beginning January 1st, 2022, you as employers are required to collect premiums through a payroll deduction equal to 0.58% of the employee wages. There is no cap on this like there is for Social Security. So the entirety of the wage gets a 0.58% reduction and withholding. Again, you as an employers are not required to contribute to the program. And then the actual program itself, once it gets into full effect, is going to be only allow you access of $100 a day, or allow the employee access of $100 a day, up to a maximum lifetime benefit of $36,500. So one unique thing about this, and this is kind of going on right now, is that Washington residents have a one chance to get out of this system if you already have private long-term care before November 1st, 2021, and your private insurance is qualified. If that isn't the case, you can fill out some paperwork and get out of the public program. Don't have to pay that out of your own paychecks. So if you buy long-term care insurance before November 1st, you can get an exemption from the previous premium assessment. If you have long-term employees and you're already providing long-term care insurance, this is something to alert them to so that they can do that for themselves as well. Because again, it's not an insignificant deduction given that it's 0.58% with no cap. And again, it's only possible to apply for this exemption between right now and December 31st, 2022. So you have, December 31st, 2021. So you only have a short period of time to, if you don't have it, to acquire it. And if you do have it, to file that exemption. Moving on, non-competition agreements. A lot of employers do include these in their employment agreements. There have been some really big changes that went into effect last year that govern when a non-competition agreement can be considered valid or enforceable under state law. So the big changes are that it now requires that the agreement be disclosed in writing to prospective employees prior to acceptance of the job. So in your job offer letters, if you're intending to have one of these non-compete agreements, you need to put that in the job offer letter, including all the terms that you're going to do. And it is limited now to employees or independent contractors who earn more than the thresholds established by this new law. So for 2021, that's 101,000 for an employee and about 253,000 for an independent contractor. It's worth noting that even with these new laws in place, the prior law and the kind of case law has always required that these types of restrictive agreements on what someone can do after they work for you are going to be subject to kind of a pretty high level of scrutiny and require reasonableness as to both time and geographic scope. And there is a presumption that a duration exceeding 18 months is going to be unreasonable, and this will be unenforceable. And there are some new penalties associated with the failure to follow these scriptures for non-competition agreements. So COVID, I could probably do a whole 3-hour presentation on COVID, and everything is changing almost daily. So I'm just going to give a little touch, and you guys may already know this all, as to what the current restrictions are just in King County. It varies county to county, it varies state to state, but here in King County, in stores, restaurants, and other public places, as of September 13th, masking is required for both employees and customers in all indoor publicly accessible places, regardless of vaccination status. That includes your grocery, your retail, your theater, your entertainment establishments. You need to post signs in a prominent location, visible to customers, saying masks are required for entry. You need to take steps to engage customers to ensure face coverings are being worn and to avoid creating potentially violent situations. So I think kind of everyone knows that and is doing that. The kind of things deeper into that order and regulation are that you need to amend, if you have an accident prevention program, your L&I accident prevention program, you need to have a customer masking policy and procedures for COVID-19 that address how customers and visitors without masks will be accommodated. And as of October 25th, proof of vaccination or a negative test within 72 hours is going to be required for everyone 12 and older to attend large outdoor events, indoor restaurants, bars, and taverns with a seating capacity of 12 or more, indoor entertainment and recreational establishments such as gyms, fitness facilities, public pools, entertainment, performing arts venues, nightclubs. And I believe there's actually a separate date that's going to apply to smaller restaurants with a seating capacity of 12 or less. And I think that's coming in November. So that's for your public facing spaces. For your employees is more complicated in some ways. You need to provide masks free of charge and replace them when they become contaminated, wet, dirty, damaged, or when recommended by the manufacturer. I think most of us are just keeping a big box of disposable masks that are available for anyone to use at all times. That covers not having to worry about, the dirty damage recommended by manufacturer, contaminated. Don't need to make that determination. Just grab a new mask when you think you need one. Those are subject to Americans with Disability Act accommodations. So if you do have someone who says there's a medical reason they can't use that, you do need to accommodate them in the same way you would with any other disability. Again, that's a dangerous and dirty road as to what that can mean, and it is changing almost daily. For non-public spaces, that's your work areas, office environment where you're not having the public in. Fully vaccinated employees whose status has been verified by the employer can remove their face coverings. People working alone can remove their face coverings just while working alone. That includes, like, I'm in my office right now, no one else, there's a closed door. So even if I were not vaccinated, I could be working in here. It also includes cubicles, as long as they have 4 walls. So they're full 6 foot around cubicles, and there's not a chance of someone coming within 6 foot of you. If you do get up, go to the bathroom, you need to put a mask on. You need to provide your employees with information, handouts, online videos, webinars about COVID and preventing COVID. This is something we haven't seen a lot of people doing. It is in the regulations. We recommend you do it. There are a lot of online resources to get this cheap or free, and then you're fully in compliance. Similar, training employees to recognize and respond to COVID-19 as a workplace hazard, just as you would with any other workplace hazard that you have in your workplace. Again, there's lots of information, online videos that are available to you free, that you can make available to your employees, which will help you. If the government comes and says, what are you doing to train your employees with respect to COVID-19? Last is assessing recognized hazards, including COVID-19, as part of your ongoing requirement to provide a safe and healthful workplace, and where appropriate, taking additional steps to protect all employees. I know everyone is really doing their darndest to do this. That includes things like extra cleanings and just keeping on top of this. And all of us as business owners are really doing that anyway, because we want to keep our people from getting sick. We want to keep our customers from getting sick. But just keeping records of those can prove useful if the government comes and audits that. Again, very unlikely, but a good best practice. One last thing, you do need to provide written notice of potential exposures within 1 business day to all of your employees, as well as subcontracted employees who are at the same work site if there is a positive test. Now, you also do have to report if you have 2 or more positive tests in King County. I believe you need to report that if they're within 14 days. I think in the state, you have to report 10 or more positive tests to Labor and Industries. I also did want to touch on this because, again, this has been in the news. You can choose to require the COVID-19 vaccine for your staff. There needs to be, you do this, you need to have a written policy applied equally to all of your staff. While you can require proof of vaccination, you cannot require the employee to provide any further medical information as part of their proof. And you need to have exclusions for medical reasons and sincerely held religious beliefs. I have a friend who's doing this for a large company right now, and they are, his job is to look through the letters and make a determination as to whether those are sincerely held religious beliefs. And I can tell you, it is no fun, terrible, and a legal minefield. So I would warn you, if you want to do this, it's something to very, very seriously consider and to keep a real close legal eye on. So for the medical reasons and sincerely held religious beliefs, you're going to need to determine if you'll require other safety measures for those folks instead of vaccination. And like I said, be very careful with this. It's a minefield. The law is developing every single day. There are new lawsuits being filed every single day about this. So, okay.
Can I ask a question on that topic as well? Okay, so we have an employee who is not vaccinated.
Okay.
As an employer, is there anything I should have in place that is essentially like a hold harmless or some kind of waiver or liability form that I should have, that I should be providing them and have them sign so that our business isn't, do you know what I mean?
Yeah.
Is there something that we can put in place? Or, I mean, it's their choice to obviously not be vaccinated, but it does have potential ramifications for our business.
So now, are you talking about to customers or to your other employees?
So I guess a little bit of both. One, for potential exposure to our other employees, our customers. Our particular business, we're landscape contractors, so we do work outside, and exposure is better mitigated that way. But so yes, on that end. And then also because they are making the choice to not get vaccinated, that leaves them more susceptible to potential exposure, or like their risk is increased. So it then becomes becomes a liability for us, because then that's additional time off that they may need, and that's cost on our end. Do you know what I'm saying? This feels like a muddy.
It does. And I can't really give you a good answer without kind of researching it. But my gut feeling is that it's going to be very hard to, you're not, any agreement you come up with the employee themselves is probably not going to be enforceable. So your best route to kind of addressing that is to strictly enforce those requirements that I just talked about for your employees. Non-vaccinated employees need to be masked. Even if they're working outside, he or she needs to be wearing a mask. You need to enforce that. In terms of your customers, is an interesting question. And I don't think I've seen anything on this yet, but it would be worth considering amending your agreements just to note that, not all of our employees are vaccinated, or we don't know the status of our employees' vaccination. We require them, any unvaccinated employees, to require masks and follow the, order of Washington State. We understand this and hold you harmless, and you can put an indemnity clause in there and have them actually sign next to that. I don't know if that's going to get you out of it. But
Right.
that's probably, your best shot at protection against that is to identify the specific risk for them and then have them acknowledge that risk and indemnify you for it.
Okay. All right.
So I see we're kind of just about out of time here. So I'm just gonna, I think maybe an easier way to do this is I'm just gonna very, very quickly go through these 2 slides. Washington, you can terminate someone for any reason, no reason at all, at any time. It's an at-will state. Don't have to give any warnings, don't have to give any notice. The only thing is you can't terminate or retaliate against an employee for belonging to a protected class or exercising a protected right. I think we talked a little bit about that at the beginning with the Washington law against discrimination, which identifies a whole bunch of protected classes. The protected rights are things like reporting safety violations and the like. So those are things to keep in mind when you're terminating someone. It also, in this litigious world we live in, if someone is in one of those protected class, or if they did make a safety report, you do have to think carefully about firing them because it does come up and that people do say, oh, you fired me for an improper reason, even if there is an improper reason. So kind of a couple of things you can do to protect yourself against that. Clear recitation of the rules. An employee handbook with acknowledgement is great if you can do that. Documentation of underperforming employees and accurate performance reviews. Again, this is really important stuff because if you have things well documented and then they come back and say, no, you're firing me, because I reported a safety concern. No, we aren't. We've documented this, for the last 6 months. We've given you warnings. It's very obvious why we're firing you. Fair treatment of terminated employees in comparison to other employees. Again, every situation is different, but if you have 2 employees who both violated the same rule and have the same record, give them the same punishment, and it makes everything more defensible going forward. Documentation of the reason for termination and why lesser discipline was not sufficient and follows policy. That's just a good idea. You in Washington don't have to give a reason, but there is a law that will allow the employee to write you and say, I need to know the reason, and then you have 10 days to respond to them. So if you have it written down, not only is it good for following that law if you have to do it, but it also gives you that nice record of exactly why you fired them at the time. Logistics, prepare your documentation, make sure to arrange for shut off of both IT and physical access. This is something people forget about and then email their IT person and say, how do I turn off their email? They're still getting their emails to their BlackBerry. They're still able to access customer lists. So just make sure you have that all lined up so you can cut those off in one single thing. You do need to pay all wages due at termination, including accrued and unused vacation. In Washington state, you just need to do that by the next pay period, just like you regularly would, just include everything in that last paycheck. And lastly, keep your employment records for 3 years as required by the state. Does anyone have any questions? I know I kind of rushed through that, but I do want to keep us moving through so you guys can get back to your busy lives. Okay, well, thanks so much for joining us today, and thank you to the chamber for letting us do this.
Yeah, thanks, Mike. That was really great information, just start to finish. Yeah, thank you.
Thanks, everyone.
All right. No other questions? Nothing to wrap up? All right, speak now, forever hold your peace.
Thanks, Mike.
Thanks, bye.
All right.
Mike.
Let's see. Cool. Good time. Oh, hey, Stephen. Glad you were listening in. I don't think we could, I don't know if your audio was working. What do you think, Aaron?
I thought that was great. Sorry, I was late.
No, no worries. I mean, you were literally, we had started 15 seconds before that, so no problem.
Excellent.
Yeah.
That was fantastic.
Yeah,
So thank you for putting that on.
sure, for sure.
And I'll probably reference it again when it's
Yeah,
a lot of stuff to digest.
yeah, sure is. Yeah, I think I thought it was just super relevant, just start to finish. So
Yeah,
yeah, like you said,
good job.
there's lots to digest there.
Yep.